Morning on this episode of Law Weekly, the Lagos State Judicial Panel on Restitution for Victims of SARS-related abuses and other matters gets another 3 months extension, while panels in other states wind up and submit reports. We also have reactions trailing the debate on the PIB bill and the pegging of funds accruing to host communities, plus our recap of some of the top legal stories in the news. Hello and welcome to the program. I'm Shola Shoyeli. The Vice President, Senior Advocate of Nigeria, Professor Yemi Oshibajo, has said that the National Executive Council, NEC, would convene a special session for deliberation on implementation of the reports of the judicial panels set up late last year to address the concerns of the Nigerian people on police brutality, allegations, and other related issues. In a statement by his media aide, Laolu Akonde, the VP disclosed that the decision to convene the special session was taken at a meeting of the council held on Thursday, June 17. But what's there for the council to deliberate on? So far, some states like Ogun, Oyo, Ondo, Ekiti, Edo, Imo, and Anambra states have submitted their reports to their state governors. States like Borno, Jigawa, Kano, Kebbi, Sokoto, Yobe, and Zamfara were said to have ignored the FG's directive as they did not set up panels.
My learned friend, Esquire.
In Lagos, there's still a large number of petitions yet to be heard. The panel, which was set up on the 27th of October 2020 for a 6-month period, had its tenure extended for another 3 months, with a deadline put at the 19th of July. As at Saturday, July 17, the panel has sat for 105 days and only heard 126 petitions out of the 235 petitions it received. Of the 126, 89 cases remain partly heard, while 37 had been concluded. 109 petitions remain unheard, necessitating the request for an extension of time. On Friday, July 16, the chairman of the panel, Justice Doris Okuobi, disclosed that the tenure of the panel had been extended again for another 3 months. This means that the panel will now sit until October 19, a day before the October 20, 2020 shootings at the Lekki Toll Gate. But the issues of what happened at the Lekki Toll Gate on the night of October 20 is still being heard at the panel and are far from determination. The consultant pathologist to the Lagos State government, Professor John Obafunwa, has appeared before the panel 4 times. On one of those sittings, he testified that the coroner's office conducted post-mortem autopsies on 99 bodies, which were picked up from different locations between October 20 and 27, 2020. In an earlier testimony, the witness had also said that only 3 of the bodies came from the Lekki area. At the proceedings on Tuesday, the 13th of July, while being cross-examined by counsel to the Lagos State government, Senior Advocate of Nigeria Olukayode Enitan, the pathologist gave a breakdown of the locations where the bodies were said to have been picked from and the condition in which they were received before autopsy was conducted.
A number of bodies, they were already decomposing. Various grades, mild to moderate. Most of the bodies had been embalmed prior to autopsy.
Yes, you said all of that in your evidence in chief.
We had about 20 bodies allegedly from Fagba. And I think they were all charred bodies.
By charred, you meant they had been burnt?
Burnt. Almost subtotal cremation.
How many were those?
About 20 bodies from Fagba.
From Fagba, 20. Burnt. Were they known or unknown?
I think most of them were No, unknown. I know that 6 bodies came from Ikorodu. Again, showing varying degrees of decomposition, but embalmed to arrest the decomposition. Even the ones that allegedly came from Ikoyi prisons,
Yes.
some of them were already showing decomposition. That will be a general comment, sir.
Okay.
It is true that the 2 bodies from Isolo were allegedly brought in by their relations.
Yes, and the other
And
ones?
the 5 from Lagos Island Mortuary came in from Adeniji, I believe Adeniji Adele.
Identity Adele exists.
4 of them and 1 from Ebutemeta.
While giving specifics of each of the 99 bodies, including details of names where available, location, time and cause of death, the pathologist was emphatic that only 1 person died from damage to a major blood vessel as a result of gunshot injuries sustained at the Lekki toll gate.
Of all these 99, only NSAS Yaba 2020-062 is attributed or was attributed to Lekki toll gate and allegedly on the 21st to have been shot at that location.
I have 2 referred to as Lekki toll gate.
Yes, 1 gunshot, that is 062. The second one is blunt force trauma and another one at Lekki Bridge.
Wherever Lekki Bridge is, I wouldn't know.
Yes. So those are the 3
Yes, sir.
that have to do with this environment.
Yes, sir.
And of
Yes,
those
sir.
3, only 062 NSAS Yaba 2020-062 is said to have died of gunshot injury on the 21st at Lekki toll gate. That's the third case.
On the
Yes.
21st.
Yes.
That's correct, sir.
The remaining were of deaths that are reported to have occurred at Ikoyi prisons, Ikotun police station, Ojota, Bariga, Ikeja, Aja, Ifako, Mushin, Denton in Ebutemeta, Ketu, Kirikiri, SARS Ikeja, Teju Osho, and Lagos Island General Hospital and Environment. Is that correct?
Correct, sir. And Fagba.
And Fagba, yes. I think I mentioned Fagba. Oh.
The counsel
and Fagba.
also asked the witness technical questions bordering on his experience of gunshot wounds.
It will be safe to assume that when you examine a body allegedly shot, from your examination, whether you find a bullet lodged in the body or not, you'll be able to tell if indeed that individual was shot.
To a very large extent.
It would also be safe to assume that from that examination, you can also determine the type of gun that was used. Yes, whether it is a low velocity or a high velocity kind of ammunition. Would that be correct?
To some extent, depending on the state of the body, while recognizing the fact that there are two broad categories in terms of classification.
Of gunshot injuries.
A handgun.
Handgun.
If a handgun,
Yes.
or any rifled weapon has been used, you expect the bullet to have been discharged from it. It's different from where a shotgun has been used that releases pellets.
Now, guns that discharges pellets, from your experience with gunshot injuries, would that be consistent with law enforcement agencies?
We don't see that with law enforcement agencies. No.
They do not see guns that fire pellets with law enforcement agencies.
No.
So where someone is alleged to have been shot by a law enforcement agent, and on examining the body, the injury is consistent with pellets, a gun that fires pellets, you would automatically rule out law enforcement agency.
That's correct, sir. That is in an organized manner, except you have one irate.
Which would now not be consistent with his law enforcement duties.
Yeah.
Since he's not supposed to carry a shot, those kind of guns. Now let's go to the autopsy reports, the postmortem reports. Every of the 99 bodies examined were based upon the order of a coroner.
That's correct, sir.
After this testimony, further evidence from the pathologist was adjourned indefinitely to await details on whether the tenure of the panel would be extended. With the extension now granted, the panel will communicate the next adjourned date to all parties. Welcome back. The proposed 3% equity share for the oil host communities was also a much contested issue during the harmonization of the Petroleum Industry Bill by lawmakers in both chambers. We have the reactions of some senior lawyers to this issue up next.
There are many who feel that what has been done, like in normal human affairs, is not a perfect document, which I agree with them, because I expected that with the ongoing agitation, the bill will be able to put the oil-producing states and the communities in a more better focus and ensure that whatever is realized from that industry gives them first and foremost the benefit of the investment, because they are the people that suffered most. You know what is going on in the oil producing areas, the investment, oil spillage, the water, they don't have water to drink again, they don't have land to farm. And many of that, including the health hazard that the petroleum spillage have caused, and then the exploration has turned the environment into. So it was my expectation that the bill was going to do much more than what it has provided, and then give the oil producing communities and the state a first charge on the bill. I see something like 3% to wherever the pipelines have passed, to give some degree of protection to the where pipelines have passed, and then ensure that the communities or the states that are around the areas where pipelines pass through protect the pipelines. Well, I don't see much. I don't quarrel much with that, but is similar things being done to other resources from other areas? Because it is things like this that bring up agitation, that the one that is from our own area is what is being used in developing the entire country, why the one that is in other areas is being preserved in those areas and utilized in those areas. The problems being faced by the various communities, the pains they are passing through, is what this law, not just this law alone, including the Constitution itself, which is the ground norm. People should be honest, our leaders should be honest with themselves and ourselves, and should be able to come to terms and say, it is high time we sit down together. And like I have given the example, say even in a marriage, people sit down and discuss the terms of their relationship. So why can't we sit down as a country, as a people, to agree on what will be the terms upon which we operate? Nobody is talking about seceding from Nigeria, but we should be able to agree on a mutual terms on how we should continue operating.
Right from 1960, we've not had a very holistic bill that seeks to address the petroleum industry. So the bill is one of the most welcome, most anticipated bill. But then, what is the intent of this bill? It basically seeks to regulate, to streamline the upstream and the downstream sector, especially the downstream sector of the petroleum industry. Basically, to give a clear headway on how this industry is to be run. And substantially before now, the NNPC has been shrouded with the kind of account that is not durable to the people. But then, what do we seek to achieve? Now, the critical section where there have been a lot of disparity is the host community. What percentage should go to the host community? Because we're talking about corporate social responsibility here that meets international standards. There have been a lot of petroleum leakages, oil spillage in the Niger Delta. But then, that is one of the aims of the bill, is to address that issue. So the community is asking for 5%, which I think is the minimum that we should get, not 3%. Because if we don't get that right, the intent of this bill will be defeated greatly, because that is the center of the agitations of this petroleum industry bill over the years. So we must get it right. If we don't get it right, I mean, from 3% to 5% is fair enough. Because if you don't do that, you are going to negate extensively the corporate social responsibility you are trying to engender. I want to know what is corporate social responsibility, to have an amicable and a peaceful atmosphere so that the oil industry will drive, and so that it will propel and give us a better outcome in oil production. So it is very key that we allow this 5% agitation to go through, so that the petroleum industry bill will be seen and be welcomed by everybody. Because right now it is seen as being very oppressive by the powers that be. So I think, and it's my position, that we should allow this 5% to go in, and that is a critical juncture. And of course, decoupling the NNPC is very key. The commercial nature of the NNPC that is being envisaged in the bill will make the NNPC more productive, more accountable to the people. And of course, the shares can be bought by everybody, and then of course, it becomes a commercially oriented entity.
And just before we go, a recap of some of the top legal stories that made the headlines.
We begin with the report that the People's Democratic Party is asking a federal high court in Abuja to sack the Zamfara state governor, Bello Matawalle, over his defection from the party to the All Progressives Congress, the APC. In view of an earlier judgment of the Supreme Court that the APC had no candidate in the 2019 governorship election, having not conducted valid primaries, two members of the PDP in the state are contending that it will be unlawful for the governor and his deputy to retain their offices while defecting from the PDP to the APC, thereby transferring the party's victory. They are asking the court to declare that the governor and his deputy resign from their offices and allow the Independent National Electoral Commission conduct a fresh election within 3 months. Also in Abuja, the Federal High Court has threatened to issue a bench warrant for the arrest of former Aviation Minister, Senator Stella Odoa, if she fails to make herself available for trial on October 19th in an alleged 10 billion naira fraud case against her. Justice Inyang Eko issued the threat following the refusal of the former minister to honor court proceedings. The senator representing Anambra North Senatorial District in the National Assembly was billed to be arraigned on a 25-count charge along with 4 others. They are charged with conspiracy and money laundering and maintaining anonymous bank accounts with First Bank PLC. Counsel to the EFCC, Hassan Liman, said all the defendants have been served with the charges as ordered by the court. He adds that 32 witnesses have also been lined up to testify against her and 8 others with a view to establishing the fraud charges against them. In yet another case, a former group managing director of the Nigerian National Petroleum Corporation, Andrew Yakubu, has told the court that the $9,772,800 and £74,000 recovered in cash from him by the operatives of the Economic and Financial Crimes Commission were gifts from friends during occasions and celebrations. Mr. Yakubu gave the testimony under cross-examinations by the EFCC in his trial before Justice Ahmed Mohammed of the Federal High Court in Abuja. He said most of the money came after he left office in 2014. He cites the celebration of his 60th birthday in 2016 as one of the occasions. He also said that some of the money came from the wedding of children, tournaments, and the launching of Foundation for Youth and Women Empowerment in multi-skill trainings which he undertook. The witness also said that the friends that gave donations were so numerous and the show of love was overwhelming, so much so that he cannot count or recall who they are. Justice Mohammed has adjourned the matter till the 29th of July for further cross-examination and continuation of trial. And we round up with a report that the Lagos-based lawyer Malcolm Omirobo has written an application to President Muhammadu Buhari to seek a license to possess a 6.147 premium AK-47 assault rifle to defend himself. Omirobo said he was disturbed by the rising cases of armed violence and kidnapping and needed to arm himself with the weapon. In his application dated July the 8th, the lawyer said he is medically fit, of sound mind, and has not been convicted of any offense involving violence or threat to violence in the last 5 years. He cites certain provisions of the Firearms Act 2004, which empowers the president to license applicants and urges the president to accede to his request. According to him, in the face of insecurity in Nigeria, many Nigerians have talked about the need for Nigerians to bear arms, but nobody, according to him, had taken the pains to apply for firearms under the category recognized by law.
And that's our program this week. Don't forget that you can find these and past episodes of the program on our YouTube page. I'm Shola Shele. Thank you for watching and see you next week.